When the government points the finger and formally calls you an accused, what constitutional protections immediately kick into gear? I mean, what is the foundational blueprint that demands fairness, a level playing field in our justice system?
Right.
This is a question most of us hope never to face directly, but understanding the answer.
Well, it's essential to understanding American freedom.
It really is.
Today, we are taking a deep dive into the absolute safety net of that system, the Sixth Amendment.
That's right. And we're drawing on a wealth of constitutional annotations, landmark Supreme Court decisions, and, some really detailed legal analyses to truly unpack these guarantees.
And the mission here isn't just to read the text of the amendment.
No, not at all. Our mission is to translate these dense legal concepts. I mean, the shifting power of the jury under a case like Apprendi, or the ultimate standard for a lawyer's competence under Strickland.
Or even the difference between the Messiah and Miranda rules, which can get confusing. Exactly. We want to translate all of that into language that clarifies exactly how these rights protect you, the citizen, regardless of which jurisdiction you find yourself in. We are decoding the ultimate rules of engagement.
Okay, let's unpack this. It's a monumental piece of legislation. The Sixth Amendment guarantees 8 core rights to anyone who is criminally accused.
Right.
Let's just run through them quickly. You have the right to a speedy and public trial, the right to an impartial jury, the right to have that jury drawn from the state and district where the crime was committed.
That's vicinage.
Right, vicinage. Then the right to be informed of the nature and cause of the accusation. That's notice.
Yep.
The right to confront the witnesses against you. The right to compulsory process for calling your own witnesses. And finally, the big one, the assistance of counsel for your defense.
It's a pretty comprehensive list.
It sounds incredibly comprehensive, but there's a massive historical asterisk on that list, isn't there?
There is, and it's arguably the most important context for understanding modern criminal justice. When the Sixth Amendment was first adopted in 1791, it applied exclusively to federal prosecutions.
Only federal. So if a state cop arrested you?
Exactly. If you were arrested by a state or a local police officer and charged in a state court, which is where the vast, vast majority of crimes are prosecuted, these federal constitutional protections just did not automatically apply to you.
That sounds like the definition of a massive loophole. You're basically creating 2 different standards of justice across the country.
It was a huge disparity, and it persisted for over a century. However, starting primarily in the mid-20th century, the Supreme Court began what is known as selective incorporation.
Okay, selective incorporation. What does that mean in practice?
It means that using the 14th Amendment's Due Process Clause, which, guarantees that no state shall deprive any person of life, liberty, or property without due process of law, the court slowly, case by case, began to recognize that specific Sixth Amendment guarantees are so fundamental and essential to a fair trial.
So fundamental that they have to apply to everyone.
Exactly. That the states must be held to the same high standard as the federal government.
So incorporation is essentially the legal mechanism that universalizes these rights. It's what makes sure they apply in your local courthouse just as much as in a federal one.
Precisely. Today, almost every significant protection we're going to discuss, the right to counsel, the right to confrontation, the speedy trial right, the impartial jury requirement, has been incorporated and applies equally to every state in the Union.
So the asterisk is mostly gone now.
It is. The only major exception is a very narrow aspect of the vicinage or local jury requirement. But in practice, for the average citizen, the shield of the Sixth Amendment is fully deployed no matter which jurisdiction is prosecuting them. And that's the starting point for our deep dive.
Okay, let's move immediately to part 1 then. Let's focus on the right that brings citizens directly into the machinery of justice. The right to a jury trial. This is often heralded as the greatest check on government power. But let's start with the fine print. Does the Constitution guarantee a jury trial for every single crime? If I get a parking ticket that turns into a criminal fine, do I get a jury?
No, absolutely not.
Yeah.
The right to a jury trial is not absolute for every minor infraction.
Okay.
It is guaranteed only for what the court calls non-petty offenses.
Yeah.
The Supreme Court had to draw a clear, bright line here to define when an offense is serious enough to trigger this constitutional right.
And what is that line? How do they distinguish serious from petty?
The standard is simple, and it hinges entirely on the potential punishment, not the label of the crime.
So it's not about whether it's called a felony or a misdemeanor?
Not at all.
Yeah.
The right to a jury trial applies if the maximum authorized penalty for the offense exceeds 6 months imprisonment.
Exceeds 6 months. So 6 months and 1 day, you get a jury. 6 months flat, you don't.
That's the bright line rule. If the legislature dictates that the absolute maximum jail time for a specific crime is 6 months or less, that offense is considered petty, and the government can proceed with a bench trial, that's a trial decided by a judge, without violating the Sixth Amendment.
That's a crucial distinction. It means that if a prosecutor wanted to avoid a jury trial, they couldn't charge someone with a serious crime, but they could maybe charge them with multiple low-level offenses, provided none of those individual offenses carried more than 6 months of jail time.
That's a common tactical consideration, but the court has anticipated that specific scenario.
Oh, okay.
If the government packages multiple petty offenses together and the potential aggregate sentence for all of them combined exceeds 6 months, then the defendant generally gains the right to a jury trial for the whole package.
So you can't game the system by stacking small charges.
Right. The 6-month trigger is a firm threshold based on the actual exposure, the actual risk of jail time the defendant faces.
Beyond general petty offenses, what about entire categories of judicial proceedings where the jury right just doesn't apply at all, regardless of the penalty?
There are distinct areas carved out by law and history. The right does not apply in juvenile court proceedings, for instance.
Why not?
Well, they're generally considered civil or welfare-focused rather than purely criminal, even if they result in detention. The idea is rehabilitation, not punishment, at least in theory.
Okay. What else?
Similarly, military justice, through courts-martial, operates outside the Sixth Amendment's jury guarantee. It has its own system. Another important, if niche, exception is for specialized judicial procedures, like a hearing solely designed to determine if a defendant is intellectually disabled, even if that determination is critical to avoiding a capital sentence under the Eighth Amendment.
And circling back to a dramatic example, contempt of court. A judge needs to maintain order, but what if they punish someone with a substantial jail sentence right then and there?
Criminal contempt of court presents a fascinating historical anomaly. Historically, courts wielded this inherent power to summarily punish contempt without a jury.
Just on the spot?
Right on the spot. The reasoning was that their authority to ensure immediate order would be undermined if they had to convene a jury every time someone acted out.
But that seems ripe for abuse.
It could be, which is why, modernly, the 6-month rule applies here too. The Supreme Court has mandated that sentences exceeding 6 months for criminal contempt cannot be imposed in federal court without first affording the accused a jury trial or, getting a valid waiver of that right.
So that historical power of the judge is now constrained by that same constitutional line.
Exactly. The line of demarcation between petty and non-petty punishment holds.
Okay, so once a jury is impaneled for a non-petty offense, what exactly is their constitutional mandate? Is the jury just there to check boxes on factual disputes, or is their role broader than that?
The court is crystal clear on this. The criminal jury is far more than a mere fact finder. Its constitutional role is to make the ultimate determination of guilt.
The ultimate determination.
Yes, and that involves a two-part process. They have to determine the facts, and then they must apply the law, as the judge explains it to them, to those facts. This combination mandates their independence.
So even if the evidence is so overwhelming that everyone in the room knows the defendant is guilty, the judge cannot simply step in and say, the law compels a guilty verdict.
Precisely. A judge cannot direct a verdict of guilty, no matter how incontrovertible the evidence appears. The court must not override or interfere with the juror's independent judgment. The verdict must remain solely the jury's own determination. It's a fundamental safeguard against judicial overreach.
Shifting to the structure of the jury itself, the historic common law mandated 12 jurors. Is that still the constitutional minimum today?
Well, 12 is the historical and still standard number in federal courts, but the Supreme Court has clarified the constitutional floor. In a criminal case, the size of the jury cannot be reduced below 6 members.
6 is the magic number.
6 is the minimum.
Yeah.
However, the court has made it clear that anything fewer than 6 would compromise the jury's function. Its ability to foster group deliberation, to represent a cross-section of the community, and would thus violate the Sixth Amendment.
And let's address one of the most significant and really recent constitutional shifts, the issue of unanimity. For a long time, in some states, a guilty verdict didn't require every juror to agree. That has changed, hasn't it?
It has, and this change speaks volumes about the court's commitment to the purity of the Sixth Amendment. Historically, federal trials have always required a unanimous verdict.
Right.
However, states like Louisiana and Oregon allowed convictions based on, say, 10-2 or 11-1 votes. This disparity created major controversy.
I can imagine. So what happened?
In 2020, In a case called Ramos v. Louisiana, the Supreme Court struck down those non-unanimous state jury rules.
So now it's unanimous everywhere.
It's unanimous everywhere. The ruling confirmed that the unanimity requirement is fundamental and applies equally to state and federal trials.
What was the court's specific reasoning for that, especially regarding those states that held out for so long?
Well, the court noted that the historical reasoning behind allowing non-unanimous juries in those specific states was deeply troubling.
Troubling how?
They specifically cited that the rules in Louisiana and Oregon were adopted with clear racist origins.
Wow.
Yes, often explicitly intended to dilute the effectiveness of African American or other minority jurors who might hold out against a conviction. Basically, if you could get a conviction with 10 white jurors over the objection of 2 black jurors, the system worked as intended by its drafters.
So the court directly called that out?
They did. By requiring unanimity across the board, the court confirmed that the historical purpose of the jury to ensure community consensus and prevent undue suppression of dissenting voices demands that every single juror must concur with the verdict. It was a rectification of a historical injustice that was dressed up in procedural law.
That's a massive shift. So the Ramos ruling confirmed the jury's power in determining guilt. But the role of the jury fundamentally changed even more dramatically when it came to sentencing.
Oh, absolutely.
We need to talk about the Apprendi Revolution because this shifted power from the judge back to the community, back to the jury when determining punishment.
This is where criminal justice policy and constitutional rights just collided. It created an earthquake across all sentencing schemes in the U.S.
So what was the problem it was trying to solve?
Before the Apprendi line of cases, sentencing guidelines, especially the federal ones, were often mandatory and relied heavily on judicial fact-finding. A judge could impose a sentence based on facts that were never submitted to a jury or proven beyond a reasonable doubt.
Give me an example of that.
Okay, so the jury finds the defendant guilty of, let's say, generic drug possession. But then the judge, during the sentencing hearing, finds by a lower standard of proof that the amount of drugs involved was very high, or that the defendant obstructed justice. Based on that finding, which the judge makes alone, the maximum sentence the judge could impose might jump from 5 years to 50 years.
So the judge, not the jury, made the finding that exponentially increased the potential penalty.
That is the perfect example. The Supreme Court said this practice violated the Sixth Amendment. The core rule, first established in Apprendi v. New Jersey and then clarified in later cases, is that any fact, other than the fact of a prior conviction.
We'll come back to that exception.
Right. But any other fact that increases the statutory minimum or maximum penalty must be treated like an element of the crime. Therefore, it must be found by a jury beyond a reasonable doubt, or admitted by the defendant in a plea.
The logic being that if a fact raises the penalty, it effectively defines a new, more serious crime, and the Constitution demands that a jury be the one to determine the elements of a crime.
Absolutely. The penalty is the constitutional line in the sand. This principle first gutted state mandatory schemes, notably in Blakely v. Washington, where a judge had to find an aggravating factor, like deliberate cruelty, to impose a sentence above the standard state range. The court found this judicial fact-finding unconstitutional.
And then United States v. Booker took that same logic and applied it to the vast, complex federal sentencing guidelines, which had been mandatory for decades.
The fallout from Booker was immediate and transformative. It had 2 parts. First, the court ruled that the mandatory nature of the federal guidelines was unconstitutional because they permitted this judicial fact-finding to increase maximum sentences.
And the second part, what was the fix?
The remedy was not to throw out the guidelines entirely, but to render them advisory.
Advisory, not mandatory.
Exactly. Federal judges must still calculate and consider the guidelines, but they are no longer legally bound to impose a sentence within that range based on their own fact-finding. This restored a massive amount of judicial discretion.
So after Booker, the guidelines are just one of many factors a judge considers. If a sentence is imposed under these now advisory guidelines, how do appellate courts review them? They can't just reevaluate the facts anymore.
They review the sentence using an abuse of discretion standard. This is highly differential to the trial judge. The court provided more clarity in a couple of key cases. First, in Rita v. United States, they addressed sentences that fall within the advisory guidelines range.
Okay.
Appellate courts are permitted to apply a presumption that such a sentence is reasonable. This presumption doesn't compel the judge to use that sentence, but it gives the guidelines serious weight on appeal.
And what if the judge goes outside the guidelines, maybe far outside, as is their right post-Booker.
That was clarified in Gall v. United States. For non-guideline sentences, sentences that vary above or below the range appellate courts may not apply a presumption of unreasonableness.
So they can't just assume it's wrong because it's different.
Exactly. They cannot demand extraordinary circumstances to justify the variance. Instead, the appellate court has to ensure the trial judge committed no procedural errors like, calculating the range wrong or failing to consider arguments, and then that the substantive result is reasonable, giving due deference to the trial judge's unique frontline view of the factors justifying that sentence.
That emphasis on due deference is vital. It allows judges to bring local context or even policy judgment into sentencing, doesn't it? I'm thinking specifically about the controversial disparity between crack cocaine and powder cocaine sentences.
That's the most vivid illustration of this shift in judicial power. In cases like Kimbrough and Spears, the Supreme Court explicitly authorized district judges to vary from the guidelines based on a policy disagreement with the outdated 100-to-1 ratio used for crack cocaine offenses.
So a judge doesn't have to wait for Congress to fix a flawed policy. They can use their discretion, informed by their own experience, to say that this disparity makes the recommended sentence greater than necessary to achieve justice in a specific case.
Exactly. It's a profound assertion of judicial independence, allowing the sentencing court to consider all the statutory factors, even if it means rejecting the underlying policy of the guidelines themselves.
Beyond imprisonment, does this Apprendi rule apply to other criminal sanctions? What about fines?
Yes. The rule extends to the imposition of significant criminal fines for non-petty offenses. If a judge makes a factual finding, say, about the duration of a conspiracy, that then increases the maximum potential fine under a statute, that finding has to be made by the jury.
But there are limits.
There are. The rule does not apply to a judge's more administrative determination of how multiple sentences should be served, whether consecutively, so one after the other, or concurrently at the same time.
And why is that different?
The court reasoned in Oregon v. Ice that this determination has always been within the traditional scope of judicial power after a valid conviction is entered. It doesn't increase the maximum penalty for any single crime.
That wraps up the critical role of the jury. Let's shift to part 2. The right to prepare and present a defense. This section ensures the system is genuinely adversarial.
Right, giving the defendant the tools to challenge the prosecution's case.
Let's start with confrontation, which is really the constitutional guarantee of cross-examination.
The Confrontation Clause guarantees that the accused can meet the witnesses against them face-to-face. This is fundamentally a trial right, and it serves two core purposes.
Okay, what are they?
First, it secures the defendant's ability to cross-examine adverse witnesses to test the truthfulness of their testimony. And second, and this is just as critical, it allows the jury to observe the witness's demeanor, their body language, their hesitation on the stand, to assess their credibility.
The primary barrier here, then, is hearsay, out-of-court statements being introduced without the person who made them being present. But specifically, it targets testimonial hearsay.
Yes.
What makes a statement testimonial?
This has been a huge area of litigation. A testimonial statement is typically a solemn declaration made for the purpose of establishing or proving past events that are potentially relevant to a later criminal prosecution.
So, like a formal statement to the police at the station?
Exactly. Or testimony in a prior hearing, or an affidavit. The key inquiry is the primary purpose of the statement. If the primary purpose of a police interaction is to address an ongoing emergency, think of a 911 call describing an immediate threat, the statement is generally considered non-testimonial and might be admissible.
But if the emergency is over?
If the purpose shifts to gathering information for a later prosecution, it becomes testimonial and is usually barred unless that witness comes to court and testifies.
Are there any recognized historical exceptions to this general rule?
Yes, two major ones. The first is dying declarations.
Ah, the classic.
Classic. Statements made by a victim who believes death is imminent have been a recognized exception since the founding, based on the historical notion that, well, you're unlikely to lie when you're facing your maker.
And the second exception?
The second, and often more dramatic one, is forfeiture by wrongdoing.
Tell us more about forfeiture.
If a descendant or someone acting on their behalf tries to wrongfully cause a witness's unavailability, say by murder, intimidation, coercion, or threat, they lose or forfeit the right to complain about that witness's absence.
So you can't silence a witness and then benefit from it.
Precisely. The law will not allow a defendant to do that and then claim a constitutional violation because that witness can't testify against them.
That's common sense justice applied constitutionally. What if a witness appears in court but simply claims they can't remember the events they originally told the police about? Is the confrontation right violated if the defense can't effectively cross-examine a memory that isn't there anymore?
That's a common courtroom complication. The Supreme Court has generally held that the Confrontation Clause is satisfied if the witness is physically present, testifying under oath, and available for cross-examination.
Even if they say, "I don't remember," to every question.
Even if they claim a lack of memory regarding the underlying event, the opportunity for cross-examination exists, even if the effectiveness of that examination is, greatly diminished by the witness's lack of recollection.
Okay, next up is the necessary corollary to confrontation. Compulsory process. If the government can compel people to testify against you, you must have the same power to compel testimony in your favor.
That is the essence of the Compulsory Process Clause. It's the right to have compulsory process for obtaining witnesses in his favor.
Yeah.
This is the power that gives the defendant the legal ability to compel favorable testimony, usually by serving a subpoena.
And the history books give us a fantastic example of this right being asserted against the highest office in the land.
They do. The most celebrated historical example was during the treason trial of former Vice President Aaron Burr in 1807. Burr sought to introduce evidence from a letter written by President Thomas Jefferson. And Chief Justice John Marshall, sitting as the trial judge, ruled that Burr's Sixth Amendment right to compulsory process entitled him to subpoena the president to request that key piece of evidence.
That's incredible.
It cemented the principle that this constitutional right can override even the highest executive privilege to ensure a defendant can present their defense.
That historical anecdote really underscores the gravitas of this right. When you take them all together, compulsory process, confrontation, and notice, what do they collectively guarantee?
They guarantee the criminal defendant a meaningful opportunity to present a complete defense. This cluster of rights ensures that the trial is an adversarial testing of evidence, not a one-sided presentation by the state. And this guarantee also includes the accused's personal right to testify in their own defense, which was confirmed in Rock v. Arkansas.
But the right to call witnesses can't be absolute. Otherwise, lawyers could just wait until the last minute and spring a surprise witness on the court to gain a tactical edge. Are there limits?
There are limits designed to protect the integrity of the trial process. For instance, a court may bar a defense witness if the defense counsel willfully failed to identify them during pretrial discovery.
To prevent an ambush.
Exactly. It's about preventing ambush tactics that would unfairly prejudice the prosecution's preparation. Furthermore, if a defendant claims their rights were violated because, say, potential witnesses were deported by the government, the defendant has to prove that the potential testimony would have been both material and favorable to their defense.
So it's not enough to show that a witness was just absent.
Right. You must show their absence genuinely impaired your ability to defend yourself.
Let's cover the final two pieces of this puzzle: notice and venue. First, notice of accusation. What level of detail does the government need to provide the accused?
The defendant has the constitutional right to be informed of the nature and cause of the accusation. This means the charging document, the indictment or information, must clearly allege all the ingredients, all the essential elements of the crime.
And why is that so important?
It serves three vital purposes. First, it allows the accused to prepare for trial. Second, it defines the court's jurisdiction. And third, it protects against double jeopardy later, ensuring the charge is precise enough that you can't be tried for the same underlying offense again. Vague wording, even if it's taken straight from a statute, is often insufficient.
And the vicinage requirement, or venue, the idea that the jury must be of the state and district wherein the crime shall have been committed. This determines where the trial actually takes place. How is that location determined, especially for crimes that span multiple jurisdictions?
Venue is determined by the location of the criminal acts themselves. If a crime is multifaceted, the government must prove that some element of the charged offense occurred in the district where the trial is held.
Can you give an example?
Sure. The Supreme Court emphasized this in cases involving continuing offenses like money laundering. If you commit drug trafficking in, say, District A, but all the financial transactions that constitute the charged money laundering offense happen entirely in District B, you can only be tried for money laundering in District B.
So the venue follows the specific crime charged, not just any related criminal activity.
Exactly. It ensures that the accused is tried by a jury drawn from the community that has a genuine link to the crime, maintaining that local connection that the founders intended.
We now arrive at part 3, the right to counsel. For the vast majority of citizens navigating the immensely complex legal system, this is arguably the most critical protection of all.
It really is.
And the story of how appointed counsel became a universal right is really the story of the Supreme Court dramatically shifting its position, starting from a very limited view.
And it's one of the great historical evolutions of American law. Initially, the Sixth Amendment only guaranteed the right to retain counsel. You could hire a lawyer if you had the money.
But if you were poor,
In state courts, appointed counsel was required only in capital cases, like the famous Powell v. Alabama case with the Scottsboro boys in the 1930s.
that was a powerful example of what happens when indigent, vulnerable defendants are thrown into a complex, high-stakes system without effective representation.
Absolutely. The Scottsboro boys case highlighted this systemic injustice. But even after Powell, the court in 1942, in a case called Betts v. Brady, held that denying a lawyer to a poor defendant was not automatically a violation of due process.
Not automatically. So when was it a violation?
It depended on the totality of facts.
What?
Was the defendant too young, too illiterate? Was the case too complex? Poverty alone was not enough to demand a free lawyer.
So the system was inconsistent and depended entirely on the subjective circumstances of the defendant and the crime.
Correct. That shaky case-by-case approach was finally and definitively rejected in 1963 with the landmark decision, Gideon v. Wainwright.
The famous Gideon case.
The one and only. Clarence Gideon, a penniless man accused of breaking into a pool hall, represented himself, was convicted, and famously wrote a handwritten appeal to the Supreme Court. The court unequivocally overruled Betts.
And what did they say?
They held that the Sixth Amendment right to counsel is so fundamental and essential that it must be applied to the states. Gideon made the lawyer a constitutional requisite for a fair trial.
Today, how broadly does that right extend? Do you get a free lawyer if you're charged with anything, like a low-level misdemeanor?
The right to appointed counsel is strictly triggered by the threat of actual imprisonment. The rule today is that no indigent criminal defendant can be sentenced to any term of imprisonment.
Any term?
Any term. And this includes a suspended sentence or a period of probation that could later result in jail time. You must be afforded counsel or validly waive that right. This was clarified in Scott v. Illinois and later Alabama v. Shelton.
So if the state is seeking to deprive you of liberty, you get a lawyer.
That's the bottom line.
And if an indigent defendant is convicted without a lawyer, even if they didn't go to jail for that specific crime, that conviction is essentially tainted, right?
It is. The court has ruled that uncounseled convictions cannot be used later in a subsequent counseled case to support guilt or to enhance the punishment. The constitutional flaw in the initial conviction prevents its later use.
This right exists, but when does it officially attach? Does it start the moment I'm arrested or later?
The right to counsel attaches at all critical stages of the prosecution. Legally, this begins when adversary judicial criminal proceedings are initiated.
What does that mean?
It's the moment the government commits itself to prosecution, and the process shifts from mere investigation to formal accusation. This is formalized by a charge, a preliminary hearing, an indictment, an information, or an arraignment.
Does that mean a lawyer has to be present during police investigation procedures, like a lineup?
It depends on the timing, which is the key constitutional distinction here. Counsel must be present at post-indictment lineups.
After formal charges have been filed.
Right, because the court deems this a critical stage where unfairness can easily creep in and prejudice the outcome. However, there is no Sixth Amendment right to counsel for lineups or identification procedures that occur before the suspect has been formally charged. That was the ruling in Kirby v. Illinois.
So the pre-charge phase is considered investigation, not yet the adversarial process.
Exactly.
Let's discuss the huge distinction between the Fifth Amendment protection, the Miranda right, and the Sixth Amendment protection, often called the Messiah rule, in the context of police questioning.
This distinction is paramount for understanding police procedures. The Fifth Amendment's Miranda rule protects against self-incrimination during custodial interrogation, which is usually before charges are filed. It's about fighting coercion.
And the Sixth Amendment?
The Sixth Amendment's Messiah rule, named after the case Messiah v. United States, kicks in after the right to counsel has officially attached. So, post-indictment.
And what does Messiah prevent the police from doing?
Under Messiah, once you're formally in the system and the right is attached, police cannot deliberately elicit incriminating statements from you about the pending charges in the absence of your counsel.
Deliberately elicit. That sounds broader than just questioning.
It is. This rule is designed to protect the integrity of the adversarial process itself. This applies even if the police don't directly question you. They can't use sophisticated methods like placing a secret informer or a listening post near you to extract information.
If the police violate the Messiah rule and deliberately elicit a statement without a lawyer present, is that statement automatically excluded from court?
Generally, yes. Statements taken in violation of the Sixth Amendment right to counsel are inadmissible at trial.
But there are exceptions.
Of course. The exclusionary rule is not ironclad. Two major exceptions apply. First, if the prosecution can show the evidence would have been inevitably discovered, otherwise it might still come in.
And the second one?
Second, and more commonly, a statement taken in violation of the Sixth Amendment may still be used by the prosecution merely to impeach you, to undermine your credibility, if you choose to take the stand and offer inconsistent testimony.
So it can't be used to prove you're guilty, but it can be used to prove you're a liar.
That's a good way to put it. It's used solely to prevent perjury.
We've covered pretrial and trial. Does the right to counsel follow the client through conviction and into sentencing?
Absolutely. Sentencing is considered a critical stage of the prosecution, and the right to counsel applies fully. Furthermore, if you get a suspended sentence in probation, you must be afforded counsel at any subsequent hearing on the revocation of that probation. If the state is trying to send you to jail, even years later, you need a lawyer.
What about the appeals process? Does the state have to keep providing lawyers indefinitely?
This is a crucial distinction. The Sixth Amendment only guarantees counsel for the first appeal granted as a matter of right.
Only the first one?
Right. It does not mandate appointed counsel for discretionary appeals, like appealing to the U.S. Supreme Court, or for post-conviction attacks, like filing a writ of habeas corpus. Those rights are typically governed by other principles, like due process or equal protection, not the Sixth Amendment.
Now, to the most contentious part of the right to counsel. It isn't just the right to a lawyer, it is the right to an effective lawyer. The standard for effectiveness, the Strickland standard, is famous for setting a really high bar for defendants trying to overturn a conviction.
That's right. The Strickland v. Washington standard applies whether the lawyer was hired privately or appointed by the state, and it establishes a demanding two-pronged test. You have to prove both prongs to show your rights were violated.
Let's break down the first prong, deficient performance. What does that mean in practical terms?
The first prong requires you to show that your defense counsel's performance was deficient, meaning it fell below an objective standard of professional competence.
That sounds subjective.
It can be, and courts often defer to what they see as reasonable tactical decisions by the attorney. However, performance is deficient if the attorney, say, failed to investigate crucial facts, failed to interview key witnesses, or missed obvious legal deadlines. In capital cases, for example, failing to investigate and present mitigating evidence is a very common finding of deficient performance.
So, it's not just that the lawyer lost. It's that the lawyer was acting incompetently by accepted professional standards. What about the second prong, prejudice?
The second prong is often the hardest to meet. You have to show that the deficient performance caused prejudice. This means the errors were so serious they deprived you of a fair trial, resulting in a fundamentally unreliable or unfair outcome.
And how do you prove that?
You have to show there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different.
So it's not enough to say, my lawyer made a mistake. You have to demonstrate that had the lawyer not made that mistake, there's a good chance the jury or judge would have reached a different conclusion.
Exactly. The court asks, does this mistake undermine our confidence in the outcome? If the prosecution's evidence was overwhelming, an isolated mistake by the defense lawyer probably won't meet the prejudice prong.
You mentioned plea bargaining earlier, which is where over 90% of criminal cases are resolved. What is the lawyer's constitutional duty during that critical negotiation phase?
Counsel's duty is foundational in plea negotiations. First, they have a crucial obligation to communicate formal plea offers from the prosecution to the accused. A failure to communicate an offer that you would have reasonably accepted can constitute deficient performance.
What else?
Second, the court has ruled that counsel must competently advise their client on the direct consequences of a guilty plea. For example, in Padilla v. Kentucky, the court held that ineffective advice about the mandatory immigration consequences of a guilty plea violated the Sixth Amendment. A lawyer can't just ignore the massive, life-altering consequences a conviction carries beyond the prison term.
Finally, what if the defendant wants to take control and represent themselves in court? Is there a right to self-representation?
There is. Rooted in the right to make a defense, The Supreme Court confirmed the constitutional right to self-representation. It's known as the Faretta right.
But there's a catch.
Always. This choice to waive the right to counsel must be made knowingly and intelligently. The judge has to make sure the defendant understands the pitfalls and dangers of proceeding without professional legal help.
And a judge can still deny that request, right?
Yes. A judge can deny the right if the defendant is not mentally competent to waive counsel, or if their self-representation becomes too disruptive to the orderly court procedures. You can't use the right to sabotage the trial.
And what if the court appoints standby counsel to help? What's the limit on that lawyer's participation?
The central right in Faretta is the defendant's right to maintain actual control over their own case. So the standby counsel's participation cannot be so intrusive that it destroys the jury's perception that the defendant is representing himself.
So they can help, but not take over.
Right. They can assist with motions or procedure, but they can't take over the arguments without the defendant's permission.
And a final note on self-representation, does that right extend to the appeal stage?
No. There is no constitutional right to self-representation on direct appeal. The Supreme Court views the complexities of appellate law as just requiring professional assistance.
Let's turn now to our final set of protections, which govern the timing and setting of the trial. The rights to a speedy and public trial. First, the Speedy Trial Clause. When does the clock actually start ticking for a speedy trial?
The Sixth Amendment right to a speedy trial doesn't apply to the entire period from when a crime is committed. The clock only starts once a person becomes formally the accused.
And when is that exactly?
This critical trigger attaches upon arrest or when a formal charge, like an indictment or information, is filed. This rule was established in United States v. Marion.
What happens if the government takes years to formally charge someone after they know about the crime? That pre-charge delay could still severely impair the defense. Witnesses die, memories fade.
That pre-charge delay is governed by different mechanisms, primarily the applicable statute of limitations, which sets a hard deadline for prosecution.
And if the statute of limitations hasn't run out,
then a defendant has to rely on the broader due process clause to claim a violation. To win a due process claim based on pre-charge delay, you face a very high burden.
what do you have to show?
You must show that the delay was intentional on the part of the government to gain a tactical advantage, and that it caused substantial, demonstrable prejudice to your ability to prepare a defense. The bar is high because the government is generally allowed time to conduct thorough investigations.
And what about delay at the other end, between conviction and sentencing? Does the Speedy Trial Clause protect against that?
No. In Betterman v. Montana, the Supreme Court clarified that the right to a speedy trial ends upon conviction. It does not apply to the period between conviction and sentencing. You're still protected against egregious delays there by the Due Process Clause, but not the Speedy Trial Clause specifically.
Since there is no specific constitutional time limit, it's not you must be tried within 180 days, how do courts determine if a defendant's speedy trial right has been violated?
They use the flexible four-factor balancing test established in the 1972 case Barker v. Wingo. This test requires the court to weigh the conduct of both the prosecution and the defendant.
Let's break down those four factors. What's the first one?
Factor 1 is the length of the delay. This is simply the time that's passed since the right attached. A delay has to be long enough to be presumptively prejudicial before the court even begins the full analysis. Generally, a delay approaching a year is needed to even trigger the inquiry.
Factor 2 is the reason for the delay. What kinds of reasons count heavily against the government?
Deliberate attempts by the government to delay the trial, to hamper the defense, for example, stalling until a key defense witness dies, count heavily against the prosecution.
What about more neutral reasons, like a crowded court docket?
Neutral reasons like that, or illness of a judge, still weigh against the state, because the ultimate responsibility for a speedy trial lies with the government, but they weigh less heavily. Delays requested by the defendant, however, usually don't count against the state at all.
Factor 3, defendant's assertion of the right. How important is it that the defendant actually demanded a speedy trial?
This is critical. You have a responsibility to assert your right. A failure to assert the right strongly suggests that you didn't really want a speedy trial and might have been using the delay strategically. Conversely, repeatedly demanding a speedy trial weighs heavily in your favor.
And finally, Factor 4, prejudice to the defendant. What kind of prejudice are we talking about here?
Prejudice is assessed in light of the interests the right was designed to protect. The court considers three specific types. First, oppressive pretrial incarceration. Second, the anxiety and concern of the accused. And third, the most serious, the impairment of the defense itself.
Like the loss of witnesses or fading memories.
Exactly. The longer the delay and the greater the proven impairment to the defense, the stronger the claim. And if all four factors tip heavily against the government, the only remedy is the complete dismissal of the charges, which is why courts apply this test so carefully.
Finally, let's discuss the public trial guarantee. Why is the requirement that a trial be open to the public so essential that it's enshrined in the Constitution?
The Sixth Amendment guarantees criminal defendants the right to be tried in public, primarily because publicity is a powerful check on official misconduct. It protects the accused from, star chamber abuses by prosecutors and judges operating in secret. It also encourages witnesses to come forward and reminds everyone of their serious public responsibility.
But the right to a public trial isn't absolute, is it? Can a judge ever clear the courtroom?
It is not absolute. The right can be limited if overriding interests require the exclusion of the public, and the closure has to be narrowly tailored.
For example?
A court might need to exclude the public temporarily to protect a minor victim, to protect the identity or safety of a confidential witness, or to preserve grand jury secrecy. The key is that the closure has to be based on specific findings. It can't just be for judicial convenience. And it's also vital to recall the dual nature of this transparency. While the Sixth Amendment protects the defendant's right to a public trial, the public itself, including the press, has a separate right to attend proceedings under the First Amendment.
So it's protected from two different directions.
Exactly. The court views the Sixth Amendment as ensuring the defendant has at least as much protection from closed proceedings as the First Amendment offers the public and the media.
This deep dive has shown that the Sixth Amendment is not merely a piece of old parchment. It is an incredible, robust, and constantly evolving safeguard.
It really is.
It's a structure designed to ensure the adversarial system is fundamentally fair, and its rules are the rules of the road for every single state and federal prosecution in the country.
That is the perfect summary. We've traced the history from that massive loophole of non-incorporation to the modern reality, where nearly every person facing imprisonment has an advocate and a right to an impartial jury.
Right.
And we've seen the critical shift in judicial power toward jury involvement in sentencing post-Apprendi and Booker, empowering the community to determine any fact that increases the potential punishment.
And most importantly, the expansion of the right to counsel through Gideon ensures that virtually every defendant facing jail time has a professional advocate during these critical stages, from the moment charges are filed all the way through the sentencing phase. These rules aren't static. They represent the courts constantly trying to balance the needs for efficiency and public safety against the fundamental personal liberty rights of the accused.
Indeed. We've established that the law now clearly guarantees a jury the power to determine any fact that increases your maximum possible punishment, fundamentally reshaping sentencing in America. This puts enormous, unavoidable pressure on the quality of legal defense provided, especially for indigent clients.
So here is a final provocative thought for you to consider. If the right to counsel is the great equalizer, and the Sixth Amendment promises an effective lawyer under that demanding two-pronged Strickland standard, how does the legal system genuinely ensure that the attorney appointed to protect these powerful, complex rights, from plea negotiation to investigation to securing favorable sentencing variances, is truly competent? The persistent challenge of guaranteeing quality of representation, not just its availability, remains the persistent struggle at the core of securing true justice for every American citizen who finds themselves in the system.